Good morning. Welcome to the Court of Appeals. We had originally scheduled 3 matters for consideration today. One of those got continued at the request of counsel to a couple of weeks down the road. The other case, we did not think oral argument would be of particular help to the court. In this case, we thought that oral argument would be helpful. And so that explains why we have just the one case on our oral argument calendar this morning, Mortensen versus Mortensen. Sometimes we have as many as 4 such cases, and more typically 3. But we are anxious to hear the arguments in this case. As you may know, we allow 15 minutes per side for oral argument. It's very helpful since we're both live streaming and recording the proceedings if counsel don't stray far from the microphone. Or what you say won't be picked up. And occasionally we like to go back and hear some part of the arguments. And of course, the interested members of the public who are listening in or might have some occasion to listen to the arguments want to hear everything and not just part of it. Finally, we appreciate it if when you come to the podium, you state your appearance for the record. In the case of appellant, even when you come back on rebuttal, remind us of your appearance so that here again, if we're hearing the arguments later, we have a clear indication of who is saying what when. It appears that appellant is intending to save 5 minutes for rebuttal?
Yes.
Very good. We'll make an effort to help you keep track of your time. I would also mention that while it's important to pay attention to the clock, and sit down when your time is up, there's an important exception to that. If you're in the middle of answering one of our questions, carry on. No need to stop and mention the time is up and ask for special permission. No. If you're dialoguing with one of the judges, have at it. In that one limited circumstance, the clock just doesn't matter. Otherwise, have I missed anything? Okay, then we'll hear from appellant whenever you're ready.
Thank you, Your Honors. May it please the Court, my name is Clayton Priest, and I represent the appellant, Maine Mortensen. The primary issues on appeal in this case is whether the trial court erred in finding an oral agreement when consideration was unspoken, unwritten, and was not bargained for. Additionally, whether the trial court erred in finding an oral agreement when those findings lacked sufficient terms for those essential terms. In 2005, Larry and Melanie Mortensen divorced. As an unfortunate result of that divorce, Matt and McKay Mortensen became estranged from their father. In 2007, Larry amended his will to disinherit Matt.
Mr. Priest, can I just jump in with some
Yes.
questions? Do I take it from the briefing that you're not challenging any of the district court's findings on factual terms? You're just challenging whether they constitute sufficient legal basis. Do I have that right?
That is correct.
Okay. On this question of whether the district court's findings are sufficient as a matter of law to constitute consideration, the proposed rule that you've given us turns on whether the potential lawsuit was, quote, entirely without foundation or groundless. Do I have that right?
So there were 3 different metrics under which to understand consideration. One of which is whether or not it's meritless and groundless. The other was if there was a benefit, that a challenge would actually result in a benefit to Mr. Mortensen. And the final was that there's not a bargain for exchange in regards to the consideration.
On the first metric, the question of whether it's meritless or not, as I've thought about this case, one of the things I'm trying to figure out is how and when and by whom that would be determined. In terms of the sort of what it means, is this akin to a 12b6 or is this something else in your view?
So I don't believe it's necessarily akin to a 12b6, although there should have been specific findings. The issue of consideration, including the issue as to whether or not the claims were meritless.
And what does that mean? That's what I'm getting at, is what does meritless mean?
And it's the underlying, and it's not the claims in the case, but it's the claims with regard to the probate case. And the courts, in trying to provide guidance for this, have looked at whether or not there was a good faith understanding or belief with regards to that with those claims.
And that's their proposed standard as well. So are you on the same page in terms of what the meritless determination is getting after?
I think we are looking through good faith in the terms of merit. Because if a claim is truly meritless, it cannot be asserted in good faith.
So is that a subjective determination made by the party that in theory could sue? Or is that something that a court is supposed to be objectively looking at later in terms of the potential merits of the claim?
So the court should be looking at that later in terms of the merits of the claim, particularly in this case because there was significant briefing on consideration. There was a motion for partial summary judgment that was filed. The trial court should have made specific, detailed factual findings regarding consideration.
So I just want to understand the procedural posture that you would be proposing then. So essentially what the court would have to do is conduct an analysis of the merit of the claims that were being foregone, and that was the basis for the consideration that was found here. Even though the merit of those claims isn't the subject of this litigation, right? So you're actually doing sort of a case within a case. Am I understanding that correctly?
That is correct. And largely, again, because that was raised on summary judgment, that this was a key issue of consideration that needed to be evaluated.
This feels odd to me analytically. I've struggled with this in terms of reading both sides' briefs on this, and this is why. If you've got Party A and you've got Party B, I mean, just even putting aside this particular case, but you've got Party A and you've got Party B, and Party A says, hey, I'm going to sue you, and then Party B says, no, here's $5,000, don't sue me. It feels a little odd that we'd come in years after the fact and have a court look at it and say, oh, that lawsuit wouldn't have worked, and so therefore that wasn't sufficient consideration. I mean, why isn't the thing that matters here whether the parties at the time thought this was good enough reason to exchange a thing of value, meaning the $5,000? I don't understand why we would reverse engineer this years later.
So that comes into, I think your point gets to the other point on consideration. And they're, under the case law, in looking at whether or not the grounds asserted was bona fide. And there's no factual finding, other than one finding that Maine Mortensen believed there was a claim or potential claim. There's no finding at all whatsoever regarding.
No, correct me if I'm wrong, but I thought the finding was that Maine Mortensen knew that the brothers thought that there was a potential claim.
So the finding itself is ambiguous with regard to that because it refers to the they.
Well, I mean,
It doesn't say they.
I'm reading the finding. Maine knew his brothers had or believed they had a potential claim against him and Larry's estate. So the finding is that Maine, I mean, it's sort of a two-layered finding, but the finding is that Maine knew that they thought they had a claim.
And I think maybe I can address you this question best if I talk about the other part of consideration, which is the bargain for exchange. Because I think that gets to the example that you provided.
Right.
It's clear under the restatement that in order to have consideration, that consideration, that exchange of promise has to be expressed. And that the law is more concerned with the manifest expression of that bargain for exchange than an undisclosed mental state is the frame that's used. And so in your discussion, if I were to rear end you and I got out of the car and said, don't worry about it, I'm about to sell my vehicle, and when I do, I'll give you 1/3 of the proceeds, and then you don't say anything, we don't have a contract. Even though you're forbearing on a right to sue, unless you say, in exchange for that payment, I'm not going to sue you, we don't have an exchange. At best, we have an illusory promise. And the findings.
Right, but the main point of, I mean, there's multiple main points of dispute in the briefing here. But as to this initial sort of threshold question about how valid the suit has to be, or instead whether there has to be a good faith basis for the party that could in theory threaten to sue, I'm still sort of back to this big systemic question that I've got, which is why any of that matters. I mean, let's just suppose that Party A, again, you got Party A who might sue and Party B who doesn't want to get sued. Even if the potential suit is totally frivolous, there's still value to not getting sued. You don't have to pay an attorney to defend you. You don't have the emotional stress and aggravation that comes with it. If there's property involved, you don't have a lis pendens, you don't have property tied up in some sort of proceeding. And so why isn't getting out of a lawsuit alone consideration regardless of the good faith nature or regardless of a court's post hoc assessment of the merits of it. I just don't understand why that alone isn't the consideration and is enough, full stop.
So I think in looking at Ashton versus Skeen and the Golden Key Realty case, and this has to do with accord and satisfaction, there's an example that may be helpful. The court notes that if you owe me money and I come in and say, I'll just accept less, there's no contract because there's no bona fide dispute. There has to be some bona fide dispute in order for there to be a legitimate detriment. And that gets into a finding of whether or not there was good faith. And that same rationale is also what's used in the National Bank case, which is cited by the FLEs, and those other line of cases. It's not that there can be absolutely no consideration. It's that there has to be at least a basis for the merit of the claims in order for there to be consideration. And the trial court's findings on that were inadequate because the focus was on Maine. It's one-sided, whether Maine knew they had a claim or not.
Well, but again, we're back to the line that I quoted. Quote, Maine knew his brothers had or believed they had a potential claim against him and Larry's estate. So the finding is that he knew that they thought they had a claim.
And so even if that is a sufficient finding to support that element of consideration, there's no finding that was ever manifestly expressed.
And when you say that, are you saying it wasn't manifestly expressed by the brothers?
Correct.
Okay, so what do we do with the finding of fact, and this is in paragraph 24, that Maine did want to avoid litigation? So whether there's an affirmative expression that we're going to sue you, the trial court found that Maine wanted to avoid litigation, and you're not challenging that.
I'm not, and I think that gets back to the example with the car. If the consideration is one-sided, and I may be relieved that I think that you're not going to file a lawsuit, there has to be a mutual exchange of promises in order for there to be consideration sufficient to support the finding of a contract.
So is it your contention then that the trial court needed to make a finding that the brothers, I mean, I'm a little unclear on the good faith basis, but assuming that you think that finding that Judge Tenney has read from the record isn't sufficient, then the trial court needed to find, one, that the brothers believed they had a good faith basis, they threatened to file the lawsuit against Maine, and then they said out loud, we won't file the lawsuit if you'll agree to split the proceeds with us 3 ways. Is that what you're saying is deficient about these findings, is that those extra steps weren't taken?
Yes.
Well, and one more. I think you believe that the court should have found that the claim was meritorious in the following respects.
That is correct. And in the Twitchell versus Twitchell case, I think is informative on that, because it talks about where there is an issue of significant evidence concerning a particular factor that's at issue between the parties in the case, which consideration in this case clearly was, that the district court has to make sufficient findings to allow that to be reviewed. And so we're on appeal without clear findings of what constituted the consideration of the parties when it was clearly and very vehemently disputed between the two.
I don't fully understand that. Again, if we've got a finding that one of the findings is that after the brothers learned that they had been disinherited, quote, the family held numerous discussions in order to resolve the problem. I think reading that's clear enough what the court's talking about. It thinks that they were having a discussion about the problem, meaning the disinheritance. Then there's a finding, quote, Maine knew his brothers had or believed they had a potential claim against him and Larry's estate. And then there's a finding, Judge Oliver just read it, that he's trying to avoid litigation. I don't know that it requires too much sophistry to put those 3 together and say that what the district court is finding is that he thought he was going to get sued and he promises them these proceeds so that he doesn't get sued, right?
So, but again, even with those findings, there's no mutual exchange. And there's no finding regarding when offer, acceptance, and consideration occurred. The finding that you've quoted says after they learned about disinheritance, they had numerous family discussions. We don't know, there's no findings with regard to what those discussions were.
Let me ask you a question about that, because that I feel like is analytically a separate issue. And so the first issue, the first heading in your brief is about the consideration. And the second is about the lack of findings on timing of the contract and timing of performance, and then this reserves question. Did you preserve the second issue below? Did you say to the district court after it issued its findings of fact that it had failed to make adequate findings about those three things?
There was not a specific motion to amend the judgment that was raised, if that's what you're asking.
Isn't that fatal to that argument then?
I don't think it is, because again, the court has to make sufficient findings. And the courts with regard to contracts have been clear that the courts will not make a better contract for the parties than they make for themselves.
Right, but we've got cases, correct me if I'm wrong, and I recognize this is sort of coming out of left field, so feel free to supplement with the 24J if I've got this wrong. But we've got case law that says that a party does have to preserve a claim that the district court's findings were inadequate. And I think the reason for that line of cases is if the perceived error is the district court didn't say a thing that it needed to say, and you alert the district court, then it can cure it in real time as opposed to waiting for the appeal. And so if after the district court issues its ruling, you notice that it didn't make findings to explain its ruling or findings about essential terms, you could say to the district court, hey, you didn't give us these findings. But if you didn't do that, don't you just have a preservation problem on appeal?
So I would have to submit supplemental briefing on that. Unfortunately, I am caught off guard on that question.
Well, when you do, look at the Supreme Court's opinion in, forgotten the exact name, but it's something like Easy Street.
Okay.
Because they're the court, and it's a little hard to follow, and they revisited it and tried to straighten that out when we had an opinion or two that registered our confusion. But the court makes a distinction between challenging the sufficiency of the evidence to support findings, which you don't have to do until you've seen the findings, and you can raise that for the first time on appeal, as opposed to the insufficiency of the findings, which is a facial problem, and that needs to be called to the attention of the trial court. And I may have that mixed up a little bit, but the jurisprudence is a little mixed up. But be sure that you include some discussion of Easy Street and its, or Easy Heat, and its progeny, because there the court wrestled with this insufficiency versus inadequacy issue in the language of Rule 52 that seemed a little bit at odds with some of the Supreme Court's analysis.
And off the cuff, and I don't know if it's helpful in answering the question or not, but I think and this is the Utah National Bank versus Nielsen case in Justice Frick's dissent. He talks about how the question of whether the factual inference and deductions are basically, if you're looking to say there was consideration or not, that's a factual issue. But if you're looking into whether or not that was sufficient, then you're looking at a legal issue. And I think that may resolve the question, but again, I'd have to submit supplemental briefing on that line of cases.
Before you sit down, let's just assume we get past the preservation problem, or the potential preservation problem. One of the things you've pointed to in that second issue is the failure from the district court to identify the date of the contract as being and you've argued that the date that the contract is entered is an essential term. Do you have a case that says that?
Not a specific case that says that, no.
So we'd be breaking new ground if we said that the date of a contract is an essential term. Do I have that right?
I don't think it would be breaking new ground, so to speak. I think the other cases that talk about essential terms of a contract talk about what's required to be enforced under these circumstances. And
Right,
so-
but how does the date you agreed to it affect enforcement?
So.
I mean, there's no argument, I assume there's no argument here that the date was too late, right?
Right.
The date of the agreement, so it doesn't seem to be pertinent here.
So I think it is because of the way that the agreement is set up. And it was an ongoing, as alleged, there's an ongoing agreement to provide maintenance for the properties. And so at what date that agreement comes into play, and these farm properties are rented and maintained, then there are going to be implications in the contract based on.
But is
that
there
date.
really a dispute about that? I mean, as I read the case, the only real dispute is about the sale of the property in Tooele and whether those proceeds should have been split among the brothers. And whatever date the contract was agreed to, it's long before the sale of the Tooele property.
And that's correct. However, the court in its findings found that was the only identifiable breach that was alleged, which
Right, so
arose
isn't that what we're
after the-
fighting about? I mean, it seems to me that's what we're fighting about, at least at this moment, and it seems
Yes.
like there may be additional, if the contract is upheld, right, there may be additional things that, that hopefully, but hopefully not, but possibly could, cause disagreement in the future on the agreement. But as we sit here today, the only thing we're arguing about in affecting the contract is this Tooele property sale.
That is correct.
Okay.
On that final issue, I know we're at past time, but here we go. The third issue raised in the briefing has to do with whether the 1031 exchange was itself a breach of the contract. And your argument, as I understand it, is that as a matter of law, the 1031 exchange didn't qualify as a breach because it was just effectively a exchange of property. Is that fair?
Correct.
Okay. The district court finds, when it gets to the portion of the ruling in which it's finding the terms of the alleged oral contract, it finds the quote, Maine offered to split the liquid proceeds as well as any proceeds derived from the real property equally. Even if it's true that when you sell the Tooele property, the money never gets to Maine, that it goes to Zions, and from Zions, Zions then forwards it on so that you can do this exchange of property. The $2 million is still $2 million. So even if Maine doesn't get it, why wouldn't it still constitute proceeds for purposes of that provision?
And so in looking at the case, I think you have to answer your question, you have to understand part of the allegations, which is this
Yeah.
ongoing management of a farm. The transfer of property that happens results in property of equivalent value being preserved. And so even if they're correct and that there is an agreement, that transfer of property wouldn't have been a breach because the value of that property remains in the trust, or remains as a future proceed that could be liquidated. Does that answer your question?
But correct me if I'm wrong, that there was a REPSI here, right?
That's correct.
And
There's-
these are two separate third-party transactions. This wasn't an actual, like, one property owner and another property owner actually traded parcels. We have a separate REPSI with a separate transaction and a separate REPSI with a separate well, actually more than one, because he purchased land and a condo on the second piece, right? These are all independent REPSIs.
Yes, there are multiple REPSIs, both of which, however, reference the 1031 exchange, and that the property's being transferred in context.
Right,
of the
because that's what's
1031
required
exchange.
under the IRS for you to,
Right.
for Maine to have the benefit of the 1031 exchange and not owe the capital gains tax on the sale of the property, right? But there's no challenge to the finding that the property itself was actually sold, that there was a sale, right?
There's no, that it was transferred through a 1030, sorry, that it was
Well, that wasn't my
transferred
question.
through a REPSI.
It wasn't a transfer, that it was a sale, because there's a factual finding that the property was sold. And that you're not disputing that characterization of it, right? I understand
Right.
you're challenging the conclusion as to whether
Right.
that's a breach, but we're not parsing out here whether or not there was actually a sale.
Correct, and however, the term sale is weighted when it comes to a 1031 exchange, because you can have multiple sales that are in effect a transfer of property, and that's what's recognized by 1031.
Well, I'm just not sure why that matters under the terms of the contract, at least as it was found by the district court, because again, the term that the district court uses is that they're entitled to, quote, proceeds derived. And so even if, this comes back to Judge Oliver's question, if he sells the property in transaction number one and he gets proceeds, and even if he doesn't touch that money and it immediately then goes to sort of fund the second purchase, there's still proceeds. And what the district court seems to be saying is, once there's something that we can call proceeds, they get their portion of it.
But I don't think there are proceeds out of the 1031, because what's happening is you've got property that's being exchanged, and it's identified as an exchanged property. And so there's never any proceeds that are actually realized by Maine.
But that's a tax issue, right? I mean, whether or not he has proceeds, in your view, is whether or not he's incurred a tax obligation under the IRS code, right? And that he owes the capital gains tax.
I think-
There's no doubt that he received, whether it's in the Zions account, right? It's in his name, right? He received consideration, he received the proceeds from the sale of the Tooele property. And then he decides to participate in the 1031 exchange, right, to the other property so that he protects it from capital gains tax that's owing. But that's a deferral strategy, right? It's not that he's never gonna owe taxes on these proceeds. 1031 exchanges just punt that down the road. if you ever pull it out of the investment property, right? It's not the IRS saying you're never going to owe taxes on these. This is an investment, a policy made by the federal government and the IRS to encourage property investment. So I'm kind of following up with Judge Teniers. How does that really make any difference at all here? I mean, it's not like the brothers are going to get both sides of the coin, right? If they either get, assuming the contract stands, they either get a third of the proceeds of the sale price of the Tooele property, or, they don't also get a third or interest in what was purchased, right? Because it was Maine's choice to do the 1031 exchange.
But, and our argument is that 1031 exchange, that if the agreement holds, they would be entitled to the sale of the 1030, if the 1031 property was truly sold and proceeds realized, and not exchanged as part of the consolidation of property in terms of management of a farming operation, that's the point that would then trigger proceeds that would be liquid to distribute.
So don't you have to challenge, though, the court's finding that it was, that the term of the contract was liquid proceeds? Because you have liquid proceeds. There is cash that is deposited in Zion's bank as a result of the sale of the Tooele property, right? Those are liquid proceeds, and Maine could have, but he chose not to access those proceeds.
I don't believe so because of the nature of the transaction, and the proceeds are never actually realized. And then, in looking at the alleged terms, and again, going back to the ongoing management and maintenance of the farm, it would make sense in the context that you can make decisions about how to manage and consolidate the property without it becoming liquid, that has to be a liquid asset that must be distributed.
And does the fact that he bought a condo with the 1031 exchange factor in here? Because as the 1031 exchange works, you have to spend all the money, right? And
Correct.
and the reason he added in the condo is because the value of the land in that was being purchased wasn't equivalent to the value of the Tooele property that was sold. So he had to come up with something else, right, to meet that number.
Right, and they would have, now, with regard to the condo, you're correct in how it occurred. In addition, in order to make everything work, he had to contribute his own financial resources in order to complete the purchase of the condo. But the condo itself, to the extent that portion of that falls under the 1031 exchange, they would be entitled to any future sale of that to the extent that portion of the funds was used for that exchange.
Okay, thank you. It was our questioning that put you over your time, so you'll have your full rebuttal time when you next take the podium. We'll hear from the other side.
Good morning. Justin James, counsel for the appellees Matt and McCabe Mortensen. Maine has made three main arguments why this court should overturn Judge Howe's ruling. And I'll touch on each of those arguments in my argument today, but before I do, I'd like to give the court a brief background of this case, the parties, and the dispute. I've long teased my clients that their family is cursed. And I probably shouldn't, because what's happened to the family is actually kind of sad. These parties are now the third generation of Mortensens to litigate over the same land. During trial, each of these brothers testified that when they were growing up, they were very much aware of the lawsuit between their father Larry and his siblings. Each brother testified that it was hard for them as they lost contact with their cousins and aunts and uncles. And before Larry litigated with his siblings, Larry's father, these brothers' grandfather, litigated the estate dispute with his siblings. So I tease my clients about a curse. Here we are again, the third generation of Mortensens fighting over the same land.
Can I take you to the first issue that's been briefed and argued?
Of course.
And it's this question of whether the court's findings support the determination that there was consideration. We've kind of been given competing legal visions about how this works, although it sounds like they may be more similar than competing. Your version, as I took it from the briefing, is that this turns on whether the party that potentially had a lawsuit had a good faith basis for the suit. Do I have that right? Or believed that they had a good faith basis for suit?
Yes, but you're getting, I think, a layer deeper than I think this case should even go.
Tell me why. Walk me through that.
At the outset, consideration is a basic question, and it's, was there a detriment suffered or a benefit received? If the answer to that question is yes, you don't go further. And
So
if-
do we have, in your view, do we have to look at the good faith thing at all, or do we not even have to look at that?
You don't even have to look at it. Because Judge Howell, in order to start looking at that, you're gonna have to set aside factual findings from Judge Howell. And that hasn't been briefed, and the wrong standard has been argued. That's
I mean, the response we were just given from the other side when I was asking questions along these lines was that the reason that there's something that looks like a groundlessness or a good faith analysis, something like that, is that there's at least got to be a bona fide dispute. And that does make some conceptual sense to me. If you threaten to sue some stranger for something that's completely farcical, it wouldn't really make any sense to say that forbearing that would constitute valid considerations from public policy reasons. So don't we have to do some sort of analysis along those lines?
It depends on the hypothetical, because if you change your hypothetical to add in, the claim is meritless, but you perceive it to have value or you want to avoid it, you receive a benefit from that bargain. And for consideration, you don't have to have both a detriment and a benefit, you just need one. In this case, we have both. Judge Howell expressly found that, and I'm quoting from Record 2287, Maine offered for contract purposes to resolve the claims against the estate of his mother and brothers by promising all three of them the estate would be split evenly. And Mom, Matt, and McKay accepted the offer and performed their part of the contract when they forewent the opportunity to legally challenge the bequeathments of property to Maine. And so, based on the factual findings from Judge Howell, you have both a benefit given, which is Maine wanting to forego and avoid litigation.
So you're saying that would be true even if they did not have a good faith basis for believing that they had a meritorious suit?
Yes, I am. And I think the illustration 2 from the Restatement of Contracts, Section 79 highlights that.
I took it from your briefing that you thought that there was at least a good faith component. I'll go back and read your brief again, but that was my takeaway from your brief, was that you were telling us that the floor of this is something that looks like a good faith.
I think if you got into and you ignored the benefit received from Maine, that part of the consideration that he wanted to avoid litigation, and the only portion of consideration that the court was looking at is, did my clients suffer a detriment? Then you start looking into the validity of the claims.
Well, does it even matter here, though? Because the finding of the court was that there was a good faith, Maine understood there was a good faith belief on behalf of the brothers that they had a claim, and they're not challenging any of the factual findings. So do we even need to answer that question in this case?
No, but if you answer the question, yes, we're gonna look at the merits, and I'm happy to address then the good faith basis. That's established as well from Judge Howell, that there was a good faith basis.
Let me ask you about that, though. Let me just piggyback and slightly push back on Judge Oliver's question, but I think we're getting at the exact same place. You said in your responsive brief, I thought, that the party that might have a lawsuit needs to have a good faith basis for the lawsuit. And they've come back in their reply brief, and one of the things they've said is that there's not actually that phrase in the district court's ruling. The district court doesn't actually say that they had a good faith basis for their suit. What he says in that line that I quoted several times the other side, and I'll quote it now to you, quote, Maine knew his brothers had or believed they had a potential claim against him and Larry's estate. So if we don't have a finding from Judge Howell that they thought they had a good faith basis, and if that's the legal hook, then how do you win? Like, didn't he need to say that he was finding that they had a good faith basis?
No, I don't think so. I mean, that would be a dangerous precedent, I think, to adopt, that every settlement agreement in a lawsuit, 99% of them are settled, that you need to say in your settlement agreement, your claims are brought in good faith. It also creates this dangerous concept where, imagine a case is filed, the other side countersues and says, hey, you brought this claim in bad faith under the Utah statute. If you adopted that ruling, you couldn't settle that case, because the claims brought would lack merit or potentially lack merit. And so you then have to get the district court to rule on the validity of those claims before you could ever even settle it. And so it's a dangerous precedent to start saying that you need to have a factual finding of good faith.
Well,
but-
I mean, the restatement has been kicked around in this, in section 74 of the restatement. And the restatement gives the two different examples of where forbearing a lawsuit can qualify as consideration. And the second one, at least according to the restatement, is, quote, "The forbearing or surrendering party believes that the claim or defense may be determined to be valid." And so the restatement seems to think that under this second prong, it matters that the surrendering party believes that their claim was valid. And again, their point on this sort of subpart of this issue is we don't have a finding from the district court that uses those words. We don't have a finding from the district court that they actually believed that they had a valid claim. We do have a finding that Maine knew that they believed they had a, quote, potential claim. But the daylight, as I understand this analytically, and I'm trying to sort of piece out this appeal, the daylight is that the finding is that they believed they had a, quote, potential claim, not a valid claim or not a good faith claim. And they're saying without that finding, you lose. So walk me through how you don't lose, if that's all right.
Sure. My first point that I made, which is you don't need to look at the validity of the claims or the good faith basis of the claims if Maine received a benefit. And so if he anticipated, wanted to avoid litigation, that perceived benefit is enough to suffice for consideration.
Even if it was a totally groundless, frivolous lawsuit.
Yes, because he wanted to avoid litigation, that's the factual finding, and that's a benefit received, and that's the standard. Was there a benefit received?
Would we be breaking new legal ground if we said it in those terms?
No,
In terms of this line of cases about forbearing a lawsuit and how it relates to consideration?
I don't believe so. There's several cases out there that say that consideration needs to be no more than the amount and value of a peppercorn.
What's your best case in the unique context of forbearing a potential lawsuit for the proposition that it doesn't matter whether the potential lawsuit is frivolous or not? I mean, that's the new ground that I think we would be breaking, is that in that line of cases, do we have one that currently says it doesn't matter if it's frivolous or not, that forbearing a frivolous lawsuit can still be consideration? Do we have a case that says that?
I don't know that we have a case that says that explicitly, but my argument is the cases we cite are down at the second level. The first level is consideration asks two questions. Was there a benefit given, or was there a benefit received or a detriment suffered? In this case, we have both, but consideration doesn't require both. If you have a benefit received, that's sufficient. If Maine didn't perceive any benefit, if he didn't want to forego litigation, if there wasn't those factual findings, and all we had was the consideration given was the forbearance of the claims, we would then start discussing, well, were those claims held in good faith? Were they meritorious? And then we'd be asking that question. And that's what the line of cases we've cited addresses. And so it's that second level of whether or not those claims were held in good faith.
One of the other arguments that the other side has made is that, Blue Brief, page 23, they've pointed to testimony from the brothers at trial that they never directly threatened to sue him. And one of the arguments, as I understand it, that they've made is that if they didn't directly threaten to sue him by their own sworn admission, then how can that possibly have been consideration? What's your response to that?
That is I think, oversimplification of the record. There was testimony given at trial by all of the witnesses that this issue was discussed. Record 2366 is Matt testifying, and he testifies about a conversation that he had with Maine in his truck when they're helping their mom move in the fall of 2011. And this is the testimony, quote, "He told me he didn't want to be the third generation to end up in a legal battle over this property, and thus offered to split the estate equally in order to avoid litigation." Now, what's clear from that testimony is that they are discussing lawsuits, potential claims, and not wanting to be the third generation of Mortensens fighting over property. McKay also offered similar testimony. This is record 2498, where he says Maine and McKay, quote, had, quote, discussions that Maine and McKay decided that was not going to be the route they went, referring to litigation. We were not going to fight this in court. It was a horrible situation and the outcome for our father and his siblings and our grandfather and his siblings. So there's McKay testifying about conversations he had with Maine discussing the potential for litigation.
And that was 2498, you said?
Correct.
Okay. Sorry, I derailed you. Keep going if there was more to that.
That's okay. Melanie also, the brother's mother, testified about these conversations. They all testified about how when they went in April approximately of 2011 to read the will, this big bomb was dropped on them, learning that they'd been disinherited because Larry had told Melanie after the divorce, leading up to the divorce, that everything would be split equally. Everyone's understanding, except we later learned, except for Maine's, was that everything was going to be split equally. And McKay testified that when this is record 2494, that the attorney reading Larry's will said, quote, made it a point to say if anyone was unhappy with what she had read about the sons being disinherited, she said the estate docs, they were needed to take up legal issues with those and make some sort of formal legal proceedings to challenge those. At that point, at the will reading, it was in everyone's mind that they were potentially going to be the third generation of Mortensens litigating this case. There's no question that everyone knew the rabbit in the room. My client's testimony on that they didn't have to threaten a lawsuit, Judge Howe found is consistent with family members. You have a dispute with your family members. These brothers were very, very close at that time. You don't go and start threatening a lawsuit and give them a cease and desist or a letter from a lawyer. You talk to your family. You say exactly what they testified. What are we going to do about this? And they all testified about that through the summer of 2011 into the fall. And that's when they then had an agreement. And Maine told Melanie that they had an agreement. He said, don't worry, Mom, this is record 2611. Melanie testifying, quote, Maine told me, don't worry, Mom, I've talked to them. We've worked it all out. It's all okay. It's a long answer to your question that these guys absolutely talked about the elephant in the room, which was litigation.
Okay. Thank you for that. On the second issue, which is the adequacy of the court's findings, I kind of came out of left field with opposing counsel, but you've heard it. What's your recollection of the proceedings below? Was there a motion after Judge Howell issued his ruling asking him to make findings on those three terms or no, or do you want to wait for the 24J process to play out too?
There was not another motion. I'm willing to engage in the 24J process if the court finds it instructive. But we've been litigating this case for a long time. Litigation costs money.
Right.
I don't know that we need to go there because we can address the essential, it wasn't preserved. I whispered to my colleague, I don't think we made a great argument about that in our brief though.
But you don't recall there being, as you stand here now, and I know kind of coming at this a little bit cold, but you don't recall there being a request to Judge Howell to make specific findings about the things that they're now saying he didn't make specific findings about.
No, the only post-trial motion was about the 1031 exchange.
Let's assume they get past the preservation problem on that. One of the things they've told us in the second issue is the time at which a contract is formed is an essential term. And one of the things that they've argued as to why that should be true, at least here, is that if you don't know the date on which the contract was formed, then you don't have the ability to litigate such things as statute of limitations problems and various other timing-related motions. In the unique context of an oral contract, why wouldn't we hold, or why shouldn't we hold now that this is in fact an essential term that the court needs to at minimum say this is when this conversation happened that forms the contract?
I think the answer is because it conflates the standard for what an essential term is. Under contract interpretation and enforcement, the question of whether a term is essential or not is a question of, is the term needed to determine the contract and if that contract has been broken? Because a term may be relevant to the litigation or to a defense doesn't mean and does not make it an essential term. And I had prepared this in my argument, the restatement of contracts is a good example of this. If you look at, I think it's section 33 that talks specifically about essential terms, it gives 12 illustrations. Not one of them turns on this question of the date the contract was entered. And I'm unaware of any authority that would hold that the date a contract is entered is an essential term. It would be significant new ground for this court to plow to start saying that if you enter an oral contract, you need to say specifically when the date of that contract begins.
And I asked these questions of your opposing counsel earlier, but in this case, there's no dispute that there's some sale or something that happened, before the date of this contract occurring. And so it may be an interesting academic question, but it doesn't seem to me that it has any practical application to what's happening here.
Correct.
And let me just ask you quickly about the 1031 exchange. The argument as I hear it from Maine's attorneys is that this question really turns on whether or not the proceeds were liquid, because they're not challenging the finding of the district court that Maine offered to split liquid proceeds, and that's the term used by the court in the findings is liquid proceeds. And so their position is that it's not liquid because there was essentially an escrow account at Zions Bank that Maine didn't access, right? He just directed the proceeds to be used to purchase additional property. So what's your response argument about that liquidity issue?
I've struggled with the 1031 argument because I've done a bunch of 1031s, and the argument makes no sense. But I realize that the court may not be as familiar with 1031s. You have absolute control over those proceeds, that they're held in an escrow account. If Maine told Zions, you know what, never mind, I don't want to do a 1031, or if he didn't identify any property within 180 days, he would have just received the money. It's a fiction that he didn't have the proceeds or control over them. I had a hypothetical ready that's like, if you loan me $10,000 and I say, hey, I'll pay you back with the proceeds from my car. And then I go and I say, hey, you know what, Mitch drives a nice car. I want to get one like his. So I go trade my car in. And you come to me and say, where's my $10,000? And I say, sorry, there was no proceeds from my car. I traded it in. Well, this example's even worse because I would have sold my car and told the seller, don't pay me the money, pay it to the dealership because I want to buy a new car. The 1031 argument, like I said, it's creative, I guess. I see I'm out of time. I'm happy to answer any further questions the court may have.
Thank you. We appreciate the argument. We'll hear rebuttal.
Your Honors, at the outset, is there anything that you would like me to start by addressing? If not, I'll turn first. I think most of the additional things that I was going to raise, we discussed in questioning. So I think my rebuttal can be relatively brief with the risk of saying that. With regard to the facts that were talked about and testified at trial, I think it's informative to look at the record at page 2407. And Matt was specifically asked, before you testified this morning, you're not asserting that Maine made any statements to you about having to sue him in any of the statements you've made in this lawsuit, have you? And he answered, Maine was my brother. I would never have said, you better do this or else I'm going to sue you.
But does he have to use those words? I mean, as I've thought about this problem, kicked around with my clerks and so forth, we came up with multiple sort of hypotheticals. You're sitting around a table, you're mad at each other. Party A says, I don't think what you did is right. This was really unfair. This was probably illegal. And Party B says, all right, here's $10,000. And everyone says, okay, great. Even if you don't use the magic phrase, I'm going to sue you, it's understood from what's going on that there's a lawsuit sort of out in the ether. And that's what I think they're telling us happened, and I think that's what Judge Howell is telling us happened.
But I think that fails when you look at the restatement of contract section 71 comment B, which says that the court's concerned about the manifest expression of the parties and not undisclosed intent. And that creates a troubling precedent if every time we have a discussion, I may be entering into a contract because I don't understand your undisclosed intent.
Right, but now we're back to the problem, which is that you've challenged the legal grounds, but not the individual factual findings. And you have a fact finding that, quote, Maine to avoid litigation, and then within the same finding, quote, Maine offered to split the liquid proceeds as well as any proceeds derived from real property. So if you've got these various findings from the district court that he's acting with express intent to avoid litigation, then doesn't that cover the ground that you're saying is not covered?
I don't believe it does, because and this is the matter of Whitehead case that we cited, that it's generally held that mere forbearance from an existing legal right without a request to forbear, or circumstances from which agreement can be implied, is not going to support a promise for consideration. And given the discussions that are going on, where they're not asserting a claim, they've been warned about the need to raise a claim in probate closes, they've had notice of probate, and nothing occurs.
So even if they're having family discussions, even if they're upset about the disinheritance, even if the lawyers in the course of these discussions are saying things like, hey, you'd have to file a lawsuit, you're saying that's not enough unless they make the threat more overtly?
Correct, because there's never that mutual exchange that occurs.
And in your view, does Maine likewise have to make a very overt response? So do we essentially need magic words here? We need the brothers to say, we are going to file litigation, we're going to sue you on this issue, and Maine needs to say to them out loud, okay, I don't want you to sue me, so to avoid that litigation, I will split the proceeds. I mean, do we need it to be that explicit on both sides? Is that what you're saying?
So, yes, to a degree, and I'll explain. So, it's clear in the law of contracts, when you've got an offer, acceptance, and consideration, that acceptance has to be clear and unconditional. And so if there's language that says, yes, I accept, then that's a clear and unconditional acceptance. If you have conduct by the party where they unequivocally divide assets or move something into a party's name, then again, you have an unequivocal action that manifests the acceptance of that contract. But we don't have that here. And in fact,
Well, help me out, though. I'm in finding of fact 18, and this is the one that Judge Tenney has read from several times, because it says Maine as both, one, an attempt to assuage the concerns that they had, and two, to avoid litigation, promised all three of them that the estate would be split equally. So what about that is insufficient in your view?
so I'm not saying his statement in that particular finding.
But
is
isn't that the
his statement.
acceptance? Isn't that Maine saying, here's what I'm gonna do to avoid litigation?
But then there's no offer. That you just have independently a statement, I'm going to split up the proceeds.
Okay, suppose you have an auto accident. Suppose the party A runs a red light and hits party B. And they both get out of the car, and there's damage to party B's car. And party B gets out of the car and says, what in the world? You just ran the red light. Now look at my car. I can't believe you did that. And party B pulls out his checkbook, if checkbooks are still a thing. Party B pulls out a checkbook and says, here's 20 grand. Are we good? And party A says, yeah, we're good. If I'm hearing you right, you'd say that doesn't create a contract because party A didn't actually say, I'm threatening to sue you unless you pay my damages.
So I think I think that is different. And I think that I am saying that would create a contract, but that's not what happened here, because we don't have somebody saying, here's a check, are we good? Yes. There you have offer and an unequivocal acceptance. And the parties never reached that.
Well, I mean, but now we're back to that finding. The district court says so. The district court says, quote, to avoid litigation, it uses that phrase in several different findings, and then it says Maine offered to split the liquid proceeds as well as any proceeds.
But but we haven't got to that mutual exchange.
So do we have it backwards? I'm wondering, if the offer comes from Maine, right? He says, I want to avoid litigation, so I'm gonna offer to split it three ways. Then haven't the brothers accepted that offer by not in fact instituting litigation?
And that's where it's by them doing nothing, right? How does that put Maine on notice of an acceptance? And that gets
Well, they
back
did
into
nothing.
Section 71.
They didn't
Right.
sue,
And
right?
so it's that undisclosed mental intent.
So in your view, they would have had to say to Maine, we agree to split the proceeds equally in thirds, and because of that agreement, we will not sue you.
Yes.
We need those magic words.
Something to that effect, yes. Unless there are any further questions.
Apparently not. Thank you very much. We appreciate the arguments from both sides. As is our usual practice, we'll take the matter under advisement and let you have a written decision as soon as we're able to get that accomplished. With that, we'll be in recess until
Next week.
next week. Excellent, wonderful. Thank you all.